Item
14. On behalf of officers, there anybody? You decide next week, project.
Mr. Gauhati, Learned Council makes a mention on behalf of Mr. Zetan Muli, Learned CGC, and seeks adjournment of the case after a week. Prayer is allowed, listed according.
This motion.
Yes,
My lord, I beg to mention item number 70, hearing on behalf of KM Ramin. I'm informed that he is taken consent of the opposite party. So kindly list the matter after 2 weeks.
Mr. E. Tipapo, Learned Council, makes a mention on behalf of Mr. K. Angami, the Learned PP,
Yes, my lord.
and seeks adjournment of the case for 2 weeks. Prayer is allowed, listed according.
My lord, similar to item number 19.
Item 19. Okay.
Much obliged.
Please, Lord Chiefs.
Yes.
My lord, I beg to mention here in item number 15, Lord Chief.
15, 16.
Lord Chief. Item number 15, Lord Chief.
15 and 16.
Correct, Lord Chief. In 15, I'm the appellant here. In 16, they are also. Kindly, Lord Chiefs, kindly list this matter after 3 weeks.
Your good name?
The blue muffler, Lord Chief.
The Blue Method. on the prayer of Mr. W. Murtha, learned counsel for the appellant in Criminal Appeal 6/2020, listed after 2 weeks.
Chiefs, I also like to mention item number 4, Lordship. I've taken the consent of the
Item,
item number 4, Lordship.
let it come as per the list.
For motion. Item number 1.
Confirmation of delay of 57 days.
Yes, who is the, Mr. Yangarwati, are you appearing
Yes.
for the respondent? We condone. In fact, in appeal writ petition, I think limitation like does not apply. It is only the grounds cited as to where there was a. Where's your ground? Where's your ground?
My lord, para 2 to 5.
2 to 5.
My lord.
Mr. M.T. Longcha, the learned counsel for the applicant. The application has been filed under Section 5 of the Limitation Act. Praying for condoning the delay of 87 days in filing the connected writ appeal against the order dated 25/2024, passed by the learned single judge in WPC number 72/2021. Stop. The grounds for the delay has been explained in paragraph 2 to 5 of the application. We have perused the grounds cited by the applicant, and we are satisfied that the applicant has satisfactorily explained the delay. The delay of 87 days is accordingly condoned. We have also heard Mr. Yangarwati, the learned CGC. I hear disposed. In the main writ petition, in view of the order passed in IA 143 of 2024, the appeal is admitted to be heard. Stop. Issue notice to the respondents, returnable after 4 weeks. Mr. Yangarwati, the learned CGC appears on behalf of all the respondents. Therefore, no formal notice need be issued. The learned counsel for the appellant shall however furnish the requisite copies of the appeal petition to the learned CGC within
1 week.
a period of 7 days from today. Okay.
For motion from the supplementary cause list, item numbers 20 and 21.
Your Lordships, bring for amendment to
Mr. Theo,
Your Lordship,
I think there is something missing in your prayer.
we have verified, we have incorporated vital notice.
No, I have just gone through. Yes, you can kindly come to your para 4.1
In the main petition,
in your IA. The amendment is sought for to insert some of the orders in the main writ petition, correct? Correct.
Your Lordship, where?
Your application para 4, Roman 1. You got it?
Yes.
Yes, that in the prayer, the following portion may be inserted before the prayer number 1. Prayer 1 of the main petition. So what is your prayer 1 of the main, this thing? This is to quash and set aside the detention order dated 13 May 2024. Correct? Correct. Then 2, quash and set aside the rejection order dated 11 July 2024, passed by the Special Secretary to the Government of Nagaland, and the rejection order dated 22/7/2024 of the Chief Secretary to the Government of Nagaland against the detainee's representation letter praying for revocation of the detention order so and so. Correct? This is rejection of your appeal. Representation, correct? You want to actually insert that order also. Now, coming to this third prayer, we don't see any prayer to actually impugn the order in page 165 of your petition. This is the most important order, 165. I think this was hurriedly drafted. 165 you see of your main petition. 165. Correct. Confirmation order. Okay.
Oh, Your Honor, Your Lordship, we have.
Let's see.
65.
This is your. This is WPC 17. WPC 17.
It's only 65.
Mr. I'm sorry, it's 65, not page 65.
Yes.
Yes, page 65, not 1. Page 65. You have not made any prayer to impugn this order. So even if we allow your application for amendment, it is incomplete. I think the best is to withdraw and then file a fresh writ petition.
Your Lordship,
I think that will be the best option now.
allow us to withdraw.
Yes, I think that will be the best option. You just kindly properly advise your juniors while drafting to see that all these impugn orders are brought on record. Correct? Because even if we allow your application for amendment, it will be only to the extent of quashing the order rejecting your representation. Correct? So I think it will be good if you can kindly withdraw and then impugn all these orders. Okay? Yes, please. Mr. V. Tayo, the learned counsel for the petitioner, is allowed to withdraw the writ petition with liberty to file afresh. Eligible, okay? Yes. And what is your correct? In view of the order, this is in IA. In view of the order passed in WPC 17/2024, the IA stands disposed. Okay? Yes.
For admission, item number 2.
May please, Lordships. Lordships, an affidavit has been filed by the state respondents 2, 3, 4, and 5. It was filed on the 17th. Have your Lordships got that? Yes. Now,
17th?
17th September.
On 10th.
11th. It
On
is
11th.
11th.
10th of.
I see.
10th of September.
Your filing is 10.
Yes, ma'am.
Ha.
Yeah, I received it on the 17th, so I assumed that it was filed on the 17th, my lords. Now, in this affidavit, your lordships, the state has made certain statements, and I would like to draw your lordship's attention to these statements, beginning from paragraph 4. Paragraph 5, my lord. Paragraph 5 at page 7. May I read, my lords? So this paragraph states that with regard to the statements made in paragraph 6 of the petition, the deponent reiterate to the statements made in the preceding paragraphs that the National Highway 329A was entrusted to the state PWD by the ministry, and the same was taken over by the state government from NHIDCL. Thereafter, the estimate for a performance-based maintenance contract works 2023-24 was submitted to the Ministry of Road Transport and Highways by letter dated 23rd November 2023 to maintain the road in traffic-worthy condition. However, before the sanction could be accorded by the ministry, the Lok Sabha election was declared and the model code of conduct was enforced. Thus, the same has been included to be taken up on 24-25. Simultaneously, project management consultancy work has also been included in this year annual plan, that is 24-25, for preparation of detailed project report, the pre-construction activity and construction supervision of two-laning with paved shoulder along the entire stretch of National Highway 329A from Sangtam Tila to Mainamsi. So what the state is doing its part, Your Lordship, but apparently the matter has been, a proposal has been submitted to the central government, but on the part of the central government, there has been no action forthcoming. So that part, the central government, the respondent number 1 has to answer, my lord. The last paragraph says, thus, after the ministry accorded the sanction and after completing all contract other formalities, the respondents will construct, expand, and maintain National Highway 329A at the earliest.
The stretch, which is the subject matter of this PIL, is included in 329A.
Yes, my lords. Yes, my lords. So now this is the entire stretch, my lords, from Sangtam Tila till Mainamsi. That is the stretch within the state of Nagaland.
Who is representing one? Mr. Yangarwati, are you representing one? No, have you received the affidavit filed by the state? Mr. L.T. Sanctum, kindly furnish a copy of your affidavit.
Yes, my lord.
You got it? We tell the CGC to receive instructions.
Yes, my lords. Yes, my lords.
I think that'll be appropriate.
Yes, my lords.
Mr. Mua, you are for 6 and 7. You are out.
Yes, no. That is the period the IA. I fight an IA.
To struck off your.
Yes.
Okay, let us just skip it. Nothing adverse against you. Let's just skip it.
The state has also filed their. Clearly stated that paragraph 5, 6, and 7.
No, no, no.
That the forward entrusted to the state government.
Let us just keep you for some time. We know that you have no role to play, but yes, I think as a matter of abundant caution, we'll keep you. You have no role. Okay,
Legally official, it's supposed to be IA also.
next date. At least let the central government come. They may again put something on you.
No, Your Lordship, as far as the IA filed by the NHRECL is concerned, there are already two orders by this honorable court in the division bench saying that the IA will be kept on hold and be disposed of along with the main petition.
So it's all right. We will not impose any condition. We will not ask you to file affidavit. We will not ask you to file character. Nothing of that sort. But just to be on record. Okay.
First time the central government comes with their instruction.
Yes, once the central government comes, because we never know what the center has in mind.
Very correct, Your Lordship. NHRECL may again be entrusted with the construction.
That Mr. Ajimomi. Learned counsel for the petitioner. Through VC. Mr. L.T. Sanctum. The learned counsel for the state respondent number 2 to 5, correct?
Yes, ma'am.
Mr. Yangawati, the learned CGC for the respondent number 1. And Mr. Mojamir, the learned counsel for the respondent number 6 and 7. We have new pack. There is the affidavit dated 11/9/2024, filed by the state respondents. Stop. Paragraph 5 of the said affidavit is reproduced below. Para 5 of the affidavit, okay? 11. We are therefore of the view that necessary information on the affidavit filed by the state respondents, more particularly paragraph 5, has to be placed on record by the respondent number 1. We accordingly direct the respondent number 1 to place on record the steps taken by the ministry which ministry?
Ministry of Road Transport and Highways, ma'am.
Ministry of Road Transport and Highways, Government of India, on the steps taken for the construction and completion of NH 329A. Correct?
Yes, my lord.
Yes, Mr. I think you served not one copy, you served the requisite copies. Okay. When can we fix it? 4 weeks. Stop. Mr. Yangarwati, the learned CGC, shall place the instructions in the form of an affidavit in 4 weeks' time. Okay. Mr. L.T. Sanctum, the learned additional AG, shall furnish the requisite copies of the affidavit dated 11/9/2024 to the learned CGC in the course of the day.
Yes.
Okay, listed after 4 weeks. Okay,
Yes, my lords. Much obliged, my lords.
okay. A copy of this order may be furnished to the learned CGC for necessary action.
For admission, item number 3.
Yes, ma'am. In the course of the day. Okay. MS Renzo makes a mention on behalf of MS Nito Koza, the learned counsel for the petitioner, and submits that the rejoinder affidavit will be filed in the course of the day, listed after 2 weeks.
Lordship updated for respondent number 3.
MS Apila Sanctum appears for the respondent number 3. Mr. LT Sanctum, the learned additional AG, appears for the respondent number 2 and 4, and Mr. Yangawati, learned CGC, appears for the respondent number 1.
For admission, item number 4.
Yes, please. Yes, please.
Kindly list this matter after 3 weeks, Lordship. Taken the consent of the opposite party.
You are
W. Mathur, Lordship. My name is not reflected in the.
you are mentioning on behalf of
Asia, Lordship.
Mr. Swenso. Learned counsel makes a mention on behalf of Mr. Azo, the learned counsel for the appellant, and seeks adjournment of the case for 3 weeks. Prayer is allowed, listed accordingly.
My shoulder.
For admission, item numbers 5, 6, and 7.
Thank you, Sir Lordships.
Yes.
Lordships may kindly list this matter after the puja break, my lord.
After the puja break.
Yes, my lord.
Okay.
The consent, my lord. Yes.
MS Lucino, the learned counsel for the appellant, seeks adjournment of the case for
My lordship,
3
on
weeks.
the-
For 3 weeks. The consent of the other side has been obtained, listed accordingly.
Lordship.
For admission, item number 8.
Yes.
However, Lordship, I received the extra copy just only on 29, Lordship. And within the short period, Lordship, I just received instruction, Lordship. And Lordship, I have now the signature is awaiting.
What is this case?
Your lordship, I'm challenging the impugned prevention order passed by the Commissioner of Police and District Magistrate
Okay.
and the confirmation order passed by the Chief Secretary, my lord.
Okay.
Lordship, please to list the matter.
You were served with the copies only?
Only
What about Mr.
29.
Yangawati? Oh,
It's my recommendation. Next.
Your lordship, I was informed that a subsequent event has taken place.
what is that subsequent event?
The extension preventive detention order has been extended, your lordship. So which necessitates to put it on record. So if a week time may be granted to file an amended petition.
Not amended, that will be a fresh petition. Correct, brother? Extension of detention. Huh? Will it be okay? Extension. Okay, we grant you time to file application. for
Yes, your
amendment.
lordship, a week time alone.
MS so. The learned counsel for the petitioner is allowed to file application or amendment of the petition, bringing the subsequent development on report.
Obliged, my lord.
Listed after,
A week.
listed after.
Obliged, my lord.
For admission, item number 9.
Yes,
Please, lordship.
Yes.
My lord, here I have received instruction, so kindly allow me 2 weeks time to file it.
what about the central government? Who is for the central government? Who is for the central government?
Unit of India is not the party here.
Is someone,
Not the state.
someone representing? To be seen. Central government is not a party.
Yes, my lord, your lordship, you can see the what's that?
Will central government be a necessary party? PINDPS.
Yes, because if the representation is submitted by the petitioner, the copy will be sent to the.
Yes, ma'am, I think there is something missing in your petition. I don't know how. You brother? I think, ma'am, something is missing in your this petition. Because any representation submitted by you has to go to the central government, to the state. Yes. What's the- You take instructions from your client to amend the writ petition, more particularly the cause title. MS so and so. Then counsel for the petitioner is allowed a week's time to receive instructions. Just see, okay?
Yes, your lordship.
In the meantime, you file. We are not passing any.
Much over.
For orders, Item numbers 10 and 11.
10, 11. Okay, 10. What is this IA?
Lordship is for the nation. Lordship, in the Lordship, permission was given to take fresh steps upon some respondents, Lordship, private response, Lordship. Steps have been taken, Lordship. Our service report is delivered.
Okay. Return service report on respondent number 21, 24, 26, 30, 31, 32, 34, 35, 43, 47, and 50.
Lordship, if I may be allowed to take steps to Dusty Europe upon the remaining.
Still awaited.
Lordship.
Okay. You want to take Dusty service?
Lordship.
Mr. M. Solo.
Lordship.
For the submits that he may be allowed to take steps for service of notice upon the respondent number 21, 24, 26, 30, 31, 32, 34, 35, 43, 47, and 50 by Dusty process. Prayer is allowed.
Lordship, within 2 weeks, Lordship.
Mr. M. Solo shall take steps for service of notice upon the said respondents by Dusty process within a period of 2 weeks from today, listed after 4 weeks.
Lordship, may be listed after 2 weeks, Lordship.
After 2 weeks, you will have this vacation.
Yeah, Lordship. March.
For hearing, item numbers 12 and 13.
When is I'm appearing?
Yeah.
Items 12 and 13 minutes.
Ah,
I'm appearing for the,
In 30, we are appellants.
in 13 minutes we are, no minutes, in item 12,
We are R9 and 10.
we are R9 and R10 minutes, and in 13, we are the appellants minutes. This is for hearing minutes.
yes, wait. Whether all pleadings are completed?
Yes, minutes.
In item number 12, I put petitioner. Lordship, the conducting council is being. Can you take up? It's not ready.
Who is the conductor?
Manish Singhvi.
Name is not reflected.
Yes, we will see.
Minutes, this matter requires to be heard because the government notification minutes has been set aside by the impugned order, and this has been minutes now pending for some time. So your lordship had been pleased to put it on an urgent basis.
Respondent number 1 to 3, have you filed your affidavit?
Yes, Lordship. I'm for 1 to 3.
This is in which case? There are two cases.
I for R 1 to 3 in the item number 12.
In item WA 12.
WE 12.
What about WA 7?
Then the item 15. As far as the appeal is concerned, no, I think it's a complete.
Okay, so all pleadings are completed in both the cases.
Yes. In item 13, that is the sound that pleadings have not been enclosed in the legal the appeal. For instance, the replication filed by petitioners to the from the affidavit of the state as well as the engineers. So affidavits and even the central affidavit in the PA7 has not been enclosed. The appeal.
Why?
Also, we also desire that matter to go first. The letters may go to the bench letters that may suffice also, but if your lordship desire that the appellants should find the necessary readings.
Appellants in?
WA7.
Who is you are the appellant.
And we responded 1 to 3.
Let's see who is the appellant here.
Plus, I'm appearing for the appellants in item 12. 13. 13. At item 13, I'm appearing for the appellants. So, yes.
Item 12.
Plus, item 13, I'm appearing for appellants. And that is the first appeal, my lord, before your lordship.
You're just checking the record. Please wait.
Yes, my lord.
Yes, read appeal 7. What was your?
Submitting that the counter affidavit of the union has not been by
First.
affidavit in opposite to the respondent number, the state respondents as well as the individuals, it has not been enforced. This
Okay. So we call for the records of the yes.
Lords may fix it for hearing, my lords, because it is getting postponed, my lords.
WPC.
WPC 128
Of WPC
128.
128. Listed for hearing next week.
Can it be repeated?
No, we have some difficulty. We will list it next week.
Lords, can your lordship have it in the first week of October, any date, my lords?
Pardon?
The first week of October, my lords.
Next week.
Because next week I'm not available. I'm engaged in some exercise, my lords, which will engage me. So anytime after 1st of October, my lords.
After vacation. This second is a Wednesday, it's available. Maybe not 16 or something.
That's anywhere between 1st and 9th, my lords, subject to your lordship's convenience, my lords. Lords, 3rd, 4th, 5th, my lords, whatever suits your lordship. my lords.
Have it on 23rd October.
Very well, my lords.
23rd.
Very well, my lords.
On the prayer of the learned counsel for the parties listed again on 23/10/2024. The record of the files of WPC 1/2020 shall also be placed along with the writ appeal. Okay.
Obliged, Lordship.
Grateful, Minister.
For hearing, item number 18.
What is this case? Yes. Can we finish it today? If not, we cannot keep parted.
last time when the matter was placed before this court, now your lordship has directed, not exactly directed, but asked the parties to submit written submissions, written arguments. So we have.
Was it kept parted?
Your lordship?
Was it kept parted?
No, not parted.
Okay.
But since I prepared my written argument,
Yeah.
I'm not going to go in very detail,
Hmm.
but I would like to highlight the precise points,
Hmm.
how the learned single judge has erred.
Okay, it's up to you. If we can't finish, then it'll be futile. Because we may not keep it parted. So it's up to you. We are ready, but it's up to you.
I think we can proceed.
Hmm.
Let us proceed, Your Lordship, then.
Yes, yes.
Now,
So far as the issue involved in the case is concerned, it is very simple and very short. The issue is, as per Rule 15, Clause 2, Roman 2, the fixation of seniority, the maintenance of rota quota. There are two groups here. One group is the promotees who are the debt appellants, and I belong to the direct recruits. So for fixation of the seniority among the direct recruits and the
How, Mr. CT,
promotees,
how do you interpolate the seniority? How do you interpolate?
it is 50-50. 50% promotees, 50% direct recruits. And if the recruitment is met in the same year, calendar year, so two persons.
Who should be
Now,
given the preference first?
the promotees should be
Promotees.
given first. So role has been met in that way. But the claim of the petitioner is that for the last so many years, the role has not been applied. Nagaland Food and Civil Supplies Service Rules 2002. That was not applied for a very long time. Therefore, it should not be applied. That is the contention, put-up contention. But the seniority was fixed sometime in 2018. That was the Indian order, where the seniority was fixed in accordance with the provisions of Rule 15, Roman 2. 50-50, promotees first, promotees direct. So the learned single judge came to a finding that there is nothing wrong in the application of the service rule. The seniority list has been fixed in accordance with the provisions of the service rule. And another reasoning was given that if the service rule is not followed in the past, that should not be a ground not to follow the rule even now. Therefore, the fixation of seniority of the promotees and direct recruits has been done strictly in accordance with Rule 15, Roman 2. That was the finding, and they are agreed by it. So that is the issue.
Your Lordship,
If
yes.
I'm wrong, I will be corrected, but that is the issue.
Now, two petitions were filed in 2019. One is filed with the present respondents, 3 and 4. That is numbered as the petition number 62/2019. And in this writ petition 62, the petitioners claim for counting of the seniority from the date of vacancy arose.
You are the petitioner.
No, in that, my friend Siti is the petitioner. And in that writ number 62, they also challenged the tentative seniority list of inspectors of supply as on 19/11/2018, which is at page 95 of this appeal. Now, their claim is that their seniority should be counted from the date the vacancy arose. From the date the vacancy arose, Now, the other petition is filed by the present appellant. And that is numbered as 124/2019. In that, we question, since the rules as provided in Rule 15 surplus 2, Roman 2 has not been followed. That is Quota rule from the inception of the service rules. And in view of the settled law laid down by the Supreme Court, now we cannot apply this Quota rule. Now, both the petitions were dismissed by a common judgment. That means the seniority list as on 19/11/2018 was approved. That is, and this seniority was fixed in terms of Rule 15 clause 2. That is, Kohima, very good, very good like that. So our seniority, appellant seniority was disturbed because for the first time, the department has applied the Quota rule. Service rules was amended in 2002. Now, till 2018, until this impugned seniority list was published, it was never followed. That is our grievance. So I'll let your lordship to the date of appointments and the counting of seniority, because that is important. Now, appellant number 1 and appellant number 1, he was appointed as sub-inspector of supply.
There is only one writ appeal.
Yes.
We have accepted the judgment, so no appeal has been made. No writ petition has been dismissed.
You have accepted the judgment.
Yes.
Because although the petition of the present respondents was dismissed, the seniority is in their favor. That is the question.
As Melanie
Although
has pointed
they
out,
claim seniority from the date of the occurrence of vacancy, it was not given, but their seniority in terms of
2018.
15 to
2018.
Yes,
Seniority 2018
18.
was upheld in terms of Rule 15.
Your Lordship.
yes.
Now, whether that is possible legally, that will be a question which I'll dwell on later on.
The reason why we have filed the writ petition is based in
And-
the Inner Grammars case, which says that.
Your Lordship, allow me to continue
Yes,
so that.
okay, we'll give you a chance.
Now, appellant number 1, who is the petitioner number 1 in the with petition 124. He was appointed as sub-inspector of supply on 7/9/2005. 2005, and promoted to inspector of supply through DPC on 29/2/2012. Now, inspector of supply is class 2 gazetted, and SIS is class 3 non-gazetted. Then appellant number 2.
What is this senior inspector of supply? Whether there is a post called senior inspector of supply?
Yes, there is. This is a class 3 non-gazetted post. Senior inspector, Your Lordship. No, this is not in the service rules.
No, you have written senior inspector of supply.
Yes, Your Lordship. 12 posts of inspector of supply was upgraded in 2017. Which is not in the service rules.
Then you are the appellant is the candidate
Yes.
whose post was upgraded.
We were promoted to the post of inspector of supply by order dated 29/2/2012. Both the two appellants by the same order. 29 to 2019. Then, 2012. Then respondent 3 and 4, they were directly recruited as inspector of supply and joined the post on 19/7/2012. Now, 12 posts of inspector of supply. 12 posts of inspector of supply, which is class 2 gazetted, was upgraded to senior inspector of supply by order dated 26/4/2017. This is class 2 gazetted. This also is class 2 gazetted. Now, against this 12 post upgradation of inspector of supply, 12 of the inspector of supplies, including the 2 respondents, private respondents, and the appellants were upgraded, were promoted to that senior inspector of supply. That is in July 24, 2017. So by July 2017, we were already senior inspector of supply. We were already senior inspector of supply. Now, the impugned seniority list was as on 19.
You're just clarify.
Yes.
Your case is that you were first upgraded, then the respondents.
No.
You were upgraded in the post
No,
of.
not upgraded. Upgraded after upgradation, we were promoted to that post by the same order.
Promoted to what post?
Senior inspector of supply.
Senior inspector of supply.
Yes. Before that,
You were
all of us
promoted
were
to that
serving-
post along with the respondents.
Yes.
Along with the respondents.
Yes.
And while actually sorting out your seniority, Rule 15 was applied.
No. That the promotion order followed the seniority list of 2017. 2017. So in that list, they are below us. But one crucial aspect is here, Your Lordship. 12 posts of inspector of supply were upgraded to senior inspector of supply in April 2017. And 12 inspector of supplies, including both the 2 respondents and the appellants, were promoted to that post of senior inspector of supply in July 2017. So by 24 July 2017, all of us were already senior inspector of supply, not in the grade of inspector of supply. From 2017 July, we were all senior inspector of supply. Then the impugned seniority list was as on 19/11/2018.
You say that there was a seniority list 2017.
Yes.
So as in that you were senior to the respondents.
We are senior.
You were senior. You were
Yes.
placed above the respondents.
Yes.
Ah.
And prior to 2017, all the seniority lists were counted from the date of joining the post. That is why we are saying that the department has never followed the quota rota rule. Quota has not been followed. When quota is not followed, then there is no question of application of the rota rule. And therefore, Supreme Court says that when quota rule collapse, and when the rota rule is intrinsically linked with the quota rule, then that rule collapse, not because it is illegal, but because the rule has not been applied, so it collapsed. and therefore Rota rule cannot be applied. That is, the Supreme Court has laid down.
When was the rule enforced?
That was service rules.
Yes.
Service rules was amendment was 2002. 2002. And so from 2002, the department has never followed the quota as well as the rota. Now, Your Lordship, I will come to that also again later on. But first one now, in regard to the seniority list and the application of senior inspectors supply to senior inspector of supply from inspector of supply. Here the question is, by July 2017, we were all senior inspector of supply. Then the imputed seniority list in the grade of inspector of supply was as on 19/11/2018. When we become senior inspector of supply in 2017, we are not holding the post of inspector of supply. We are already senior inspector of supply. Then in 2018, how seniority can be given as by following the quota rota rule in 2018? That is impossible. There is no such thing in the service jurisprudence, not at all.
I didn't get you on that.
Your Lordship, in 2017 April, 12 posts of inspector of supply were upgraded to senior inspector of supply. Now, by July 2017, 12 of us, including the appellants and the respondents and 8 others, were promoted to that post of senior inspector of supply in July 2017. So with effect from July 2017, we were serving as senior inspector of supply. In 2018 also, we were serving as senior inspector of supply. Till today, we are all serving as senior inspector of supply. Now, the imputed seniority list was as on 19/11/2018 in the grade of inspector of supply. When we were in 2018, when we were already senior inspector of supply, from 2017 July, then how seniority can be given in the lower grade from 2018, November 2018? This is
2018, you were senior inspector of supply. 2018.
yes. No. We were senior inspector supply from July 2017.
That's why I'm asking you whether on 19/11/2018 you were senior inspector of supply.
Yes. We are all senior inspectors of supply till now. And after upgradation of 12 posts in 2017 April, there is 2 posts 2 or 3 posts of senior inspector of supply, I'm sorry, inspector of supply, but the rest were all upgraded to senior inspector of supply. And by 2017 July, after our promotion to the post of senior inspector of supply, there is the respondents 3 and 4 are not holding the post of inspector of supply. They are holding the post of the higher grade is senior inspector of supply. And there is no more inspector of supply post in respect of the respondents.
Yes, I'm a little confused, but continue. Let us see whether I can catch you up.
Let me take your lordship to the impugned seniority list at page 95. '95 and '96. Tentative, your lordship has got it. Page 95 and 96. Tentative seniority list of inspectors of supply in the department.
They're starting from page 93.
95.
They're starting from page 93.
93. Yes. But particularly I'm referring to 95 because this is all clear. And this forwarding letter at page 23 was issued on 3rd December 2018.
This is tentative seniority list of inspectors of supply.
Yes.
In the department as on?
As on 19/11/2018.
How do I get that?
Page 95.
So what is the significance of this tentative seniority list?
The significance is that, and the illegality, in fact, the illegality in this is that one in 2018, when we are before that we are in serial number 8, 9, 10, and 11. 8 and 10.
8, 9.
10, 11.
These are the appellants.
8 and 9, I'm sorry, 8 and 10, they are the respondents 3 and 4.
8 and 10.
Yes. And 9 and
Respondent
11,
3 and 8.
8 and 10.
Respondent number
3 and 4.
4 and 9 is?
9 and 11.
9 is appellant number 1.
Yes. So the seniority list is as on 19/11/2018, and you should receive the promotion of the inspector of supply to the post of senior inspector of supply at page 72, Your Lordship.
No, let us come first to this 94. Let us I think we should first complete this seniority. Yes, make your submission on the seniority.
Your Lordship,
You are agreed by this?
Yes,
This is, you are impugning this.
yes,
Okay. Why?
because this is illegal, totally illegal.
Why?
This is also not in terms of the rules. Because in 19, the seniority list as on 19/11/2018 now is or was in the grade of inspector of supply. And as on this day, that is 19/11/2018, the respondents as well as the appellants, they are already holding the post of senior inspector of supply. And after upgradation of 12 posts of inspector of supply, our posts were upgraded, in fact, our post, 12 posts, then held by us. Us means the appellants as well as the respondents. Our post was upgraded in 2017. So
When did the respondents join service?
2002 July. 2012, sorry,
2012.
2012 July,
No, 2002.
2012,
They're the first entry into service 2002.
no, 12,
As per the seniority, they're the first entry into service. Respondent 3,
2002, 2012.
2002.
No, Your Lordship.
See the column 5. Page 94.
This is wrong. Okay. This is wrong, Your Lordship.
Are you?
This is maybe past service, but date of promotion or
No,
appointment to the
no.
present grade.
I am asking you, they're the first entry into service. This respondent number 3 is 2002. Respondent number 4 is 2006.
Yes, that is maybe other service, not in this department. For the first time, they were appointed through recruitment, direct recruitment as inspector of supply and joined the post on 19/7/2012. Before that, they might have been serving super, which the department has not indicated.
So your case is that actually on this tentative seniority list,
What?
this is a tentative seniority list
Yes,
of inspector of supply
yes,
as on
as on,
19/11/2018.
yes,
So your case is that as on 19/11/2018, since both the petitioner and the respondents, they were already in the post of a senior inspector.
yes,
So this could not have been the seniority list of 18
yes,
could not have been published showing both the petitioner and the respondents as inspector of supply.
Your Lordship. And this was relied on the Rota rule.
This tentative seniority.
Yes. Because quota rotation of seniority. Rotation of seniority. So numbers in this seniority list at page 95, number 7, promoted on 19 June 2012. 2012. Then, because this Grace Mehta, Mrs. Grace, and ourselves, appellants, we were promoted by the same order. So, the department has taken the rota rule by placing Grace in number 7, then Daria Cruz, respondent number 3, and serial number 8. Then appointed to the present grade as Inspector of Supply on 19/7/2012. Then the next one, serial number 9, is promotee.
But the tentative seniority list shows all promotees. All promotee.
That is why we are.
So where is
saying that
the space for direct recruit?
quota rota rule has not been followed. So that rule has.
Maybe there was no direct recruit candidates.
No direct recruits, yes.
Yes, that's why.
That's why.
If there is no direct recruit candidates, how quota rota will be followed? That is the issue
why-
again.
That is why the rule has already collapsed.
No.
On top of that, the post.
If there were direct recruits as well as promotees, and if the quota rota was not followed and only the promotees, then of course one can say that actually that's collapsed.
No.
But here is a question where there are only promotees,
Yes.
no direct recruits, and it is only the respondents who were first directly appointed.
Exactly, Your Lordship. That is the point. When there is a rule, it should have been followed. When there is a quota. it
No,
should have been
Mr.
followed.
Iralu, when there is a rule, but there were no direct recruits, how will the rule be followed?
Exactly. That is the point, Your Lordship. When there is a rule and when there is certain vacancies in the year, quota rule has to be applied. And when quota rule is applied,
No, that's why I'm asking
then
you,
rota will come in.
when there is no direct recruit, where is the question of quota rota?
That is exactly the point. When quota rule is there, they have not followed. That is why. that
Because
quota rule
there
has
were only
collapsed.
promotees, there were only promotees.
Your Lordship, that is what we are saying. Because there is only promotees, the quota rule has collapsed. And since inception of the rule, since quota has not been followed, the rule has collapsed. And after so many years, at the belated stage, this quota rule cannot be applied. In terms of the Supreme Court's issue. This is what we are
No,
saying.
Supreme Court must have given the decision in a different context.
No,
When candidates from both the source were available and the quota rota was not followed. If I am not mistaken.
Your Lordship,
But here is a case where actually there are only promotees.
Your Lordship, now in this sentence list, in 2007, there are 2 vacancies. Both are promotees. Now, if we are to follow the quota rule, 1-1, then in 2009, there are 3 vacancies. Now, 3 vacancies all were given to the promotees. Quota has not been followed.
No, all were given to the promotees. Why? I think there was no direct recruitment.
Why, and in fact, how the department can do like this when there is a quota of 50-50?
No, Mr. Iralu, this code is still confused because actually all the candidates are promotees.
Then, Your Lordship, let me go through in detail properly.
Yeah, I'm giving you that opportunity.
Yes, otherwise, coming to this, it may be a little confusing, Your Lordship. So,
No, but these are some of the main points which you have to satisfy this court.
yes, this is one of the main points. The other one is quota rota rule in terms of the Supreme Court decision. Now, the Supreme Court has laid down the principle. And Learned Single just says, just because the rule has not been followed in the past, it cannot be said that it cannot be followed now.
That is also the law.
That also is there.
That is also the law.
But the Supreme Court says when the quota rule has not been followed for a considerable period of time, that rule collapse.
No, we
And
will
it cannot
examine,
be
we will
applied.
examine the judgment passed by the honorable court also.
Yes.
But you've also, I think, in those cases, the candidates from both the sources were available,
No.
but the rules was not
But
followed.
That has not been applied.
But the rule was not followed.
Yes.
That is why the Supreme Court has observed that the Kota Rota rule has collapsed. Here in your case, you have only candidates from the promotees.
But.
And then
but-
when actually there are two candidates from the direct recruits, why not apply the rule?
Your Lordship. Vacancies, depending on the vacancies available. One in 2007, 2 vacancies are available. In terms of quota, one each, one promoted, one direct, because.
Okay,
reservation
Mr. Ralo, I agree with you on that. But if there is no candidate from direct recruit,
Your
what
Lordship,
happens?
there is
What
no
happens?
question Unless.
Both the
unless-
quota will be occupied by the promotees.
Your Lordship, when there is quota for direct recruits, now the department has to issue notice to the NPSC for
Uh,
direct recruit.
That was not done.
That was not done.
That was not done.
So
And
they have not followed the quota rule.
only the candidates were promoted or upgraded. See,
Then why the
so
department-
because of the lapses of the department, you cannot take undue advantage of that.
No, no.
so long as the rule
It
is there.
Not only on occasion. Till this time, the quota rule has not been followed. Not only in the post of inspector of supply or sub-inspector of supply. In all categories of posts, where there is, even if there is reservation, that has never been followed. Even in the case of other grades of service.
Yes, and only the opportunity was given to the promotees.
Yes,
Ah.
and why they have not followed the rules? And because of the not following of the rules, it has collapsed. On top of that, in 2017, 12 posts of inspector of supply was upgraded. And then quota rule also collapsed because of that.
Hmm.
It has collapsed. Then in 2018, when the respondents were already serving as senior inspector of supply, the rule was applied as on 2018. Given this quota rota, how that is possible in service jurisprudence? How that is possible? Now, just an example, just as an example. I'm assistant headmaster. Now I was promoted to headmaster in last year, 2023. From 2023, I began headmaster. Now from 2021, they are fixing my seniority as assistant headmaster. How they can be?
Your position as headmaster as on that day.
When there is no post. Because in our case, there is no post.
No post, so?
No post of inspector of supply. So against a non-existing post, how a seniority can be given?
You were promoted when? Upgraded, I mean.
Upgraded in 2017.
2017.
Posts were upgraded in April 2017.
And then 2017 you were upgraded, 2018 seniority.
Yes. After upgradation of post, there is no more post of senior inspector of supply. Then how the seniority can be counted from a non-existing post?
Okay. Yes, we will resume after 5 minutes, but very doubtful whether we can give you all this 1:15, we have a meeting again. That is the issue. Let us see.
Your Lordship,
Now I'm slowly understanding your case.
it is not that, if you cannot complete it today,
We don't know. It depends on you because we are here to listen.
then in this case, I have to go in detail, and it will take time. And if I go in detail, my friend also will go in detail.
Yes,
It will
and
take time.
we cannot, both of us last date, we cannot keep the matter apart.
That is the case we can fix. Matter case otherwise.
If you want us to hear, and if you want us to keep it part heard, maybe not next week. Next week we are not here.
Partner, we are not sure.
So we can do that also, provided.
Otherwise, what my learned friend is trying to project is the post of inspector of supplies have been upgraded in 2017.
Ah,
Seniority list was prepared in 2018.
correct.
By that time, we were already senior inspector of supplies.
There was no post of inspector.
Yes.
Ah,
Then, accepting his argument that yes, department may have done it by mistake, it's a clerical error only. The word senior was not inserted there.
the
That's
word,
why senior. Inspector of supplies
Ah.
was there and after upgradation redesignated as senior
Senior.
inspector of supplies.
ah,
When it is already upgraded and there is no post of inspector of supplies,
Exactly.
how come this list has been prepared as inspector
Eh,
of supplies?
on that,
But
Mr. City,
by that
on that,
analogy,
what was your, like, stand in the writ petition?
that was not the issue in the writ
Writ
petition.
petition.
Anyway, how, even assuming you were upgraded or it's not that you were upgraded first, thereafter subsequently we were upgraded. By the same order, by a common order, we were all upgraded. By not mentioning the word senior, how his seniority position will be affected by applying the law? Can he become senior? It is a theory, a hypothesis created so as to show
He has
an
taken
impact.
undue advantage of that.
Yes, the word senior was not mentioned, but by mentioning senior or not mentioning, how the seniority position of the employees will be affected. It has no consequences. Rather, it is a technical question my learned friend is raising, which
This is
do
not
not have the
the-
And
logical
This is a
has any final seniority been published after this? No.
Because of the dispute, maybe the department has not taken any action. And in 2017, all seniority lists, not only in respect of the inspector of supplies, all categories, whether above us or below us, all seniority will come from the date of joining the post or from the date of.
So
appointment or promotion.
will it not be proper for this court to give a direction to prepare the final seniority list also?
No.
This is only tentative.
This is clear. No. This has to go. This
No,
has to-
not this has to go, but since this is only tentative to prepare the
But-
final seniority
But
list.
this is in the grade of inspector of supply. And now all these posts have been upgraded. There is no further, there is no post of inspector of supply for us.
But by accepting that submission, how his seniority position will be improved.
Same thing, because
same.
rule cannot be applied.
What are saying?
Rule cannot be applied to a non-existing post.
The only submission is since rule has not been applied in the past,
No.
even now also it should not be applied. That is the
Well,
case.
When there is no post
Whether
in
the
a
law permits
particular
that.
grade, how a rule can be applied to a non-existing post? That is
Yes.
preposterous.
Seniority of inspector.
Now they are fixing seniority against non-existing posts. How is this possible?
So by mentioning senior or not mentioning, how his seniority will. be
And this is on the
improved
basis of
by applying the rule.
Rule 15 clause 2. Rota rule.
And where a learned single judge has done wrong, he has to satisfy.
Yes, this aspect has not been considered, and
But Mr. Jamir, if you have to accept your contention, see the date of promotion 2007, 2010, 2012. These were all in the rank of an inspector.
Yes.
Yes.
So assuming that actually the word senior was inadvertently omitted, still then actually the date of promotion is very clear. So this is the date of promotion to which the officers were promoted to the post of inspector. So that also, I think it may create confusion. Because the date of promotion as per this tentative seniority list were all the dates on which the candidates were promoted to the inspector of supply. Inspector of supply. So maybe Mr. Iralu may have some substance when he says that there was no inspector, post of inspector of supply as on 19/11/2018. And assuming we accept your contention, but still then actually your contention does not erase the date of promotion. Yes.
In 2018, one of us were holding senior inspector of supplies. Admitted.
Correct.
That position is very clear. Therefore, my question is, by mentioning senior or not mentioning senior, how the seniority position will be affected? What advantage will he get in the seniority position? Because the seniority has been arranged, promotees, Derek, promotees, Derek.
That is why, Mr. CT, will it not be proper if this court gives a direction to actually come out with the seniority list of senior inspector of this thing as on so and so, as per the rules?
They have done as per the rules. Not a single judge has-
No, because actually, like,
And,
the date is quite confusing here.
and the other point
Paragraph
is,
14 to 18.
now, seniority cannot be fixed after, in the lower grade, after the application of the post.
That is
That is the one program.
If
that is why if we have to give a
If-
direction, oh yes.
the direction is given to the department that let the seniority be fixed in the post up or in the rank up, in
Yes.
the post up,
Ah.
to be precise, senior inspector of supplies. Because the grievance is.
In accordance with the rules.
When the inspector of supply is not there,
Your Lordship,
How?
there is still.
seniority can be fixed.
litigation will
So they are
follow.
saying that that is not
Will
correct,
follow.
that is wrong.
Because
So if they want to
this-
correct it, then it be
this-
corrected.
This appeal has
And the
to be
rank of senior
finalized
inspector of supplies.
after considering all aspects.
In accordance with rules.
Then only after that, the department may proceed with the consideration of seniority.
Hmm.
And after this, after disposal of this appeal, subsequently whether any party will go further or not.
Yes,
we do
yes,
not
that
know.
is,
Yes,
there is no bar.
there is no bar, and we don't know.
There's
So
no bar.
until this is settled by, at this stage, we should
No,
direction.
No, at this, no,
there
no.
will be
It's
some debate.
just my views. I am not actually
Yes,
like,
because-
because we have not heard you.
Yes.
But whether it will serve the purpose of the case if a direction is given to actually come up with the seniority list in the post of senior inspector of
In
supply.
accordance with rules.
Yes, that's why.
Your Lordship,
What wrong will be there?
Yes.
that is. Senior inspector of supply. In the post of senior inspector of supply.
Yes.
Yes.
Because that is your
Eh,
Now,
case.
now we have no rules. Rules have not, but that incorporating the post of senior inspector of supply in this all service rules.
Oh.
So even if a direction given in terms of the rules,
Principle
based
will
on what
remain the
principle
same.
means in that case, we have to follow only the entry point into service to the plate.
Yeah.
No other option, no other option.
No, but what about the other side, the Rokota Rota?
We cannot be applied. By any means, we cannot be applied.
They have not
Instead of
changed the rules.
Seniority, senior inspector of supply. Because will is not amended. And even the post of senior supply has not been incorporated in the old rules. 2002. So we are out of service rules now. But now the department is trying to bring the service rules. Clause 52. How that can be possible?
What was the conclusion of the learned single judge?
Paragraph
Learned single
14 to
judge said
18.
that
Paragraph 14 to 18 of this Indian list. The learned single judge said that the role may not have applied in the past, but that it cannot be a ground not to follow the rules. And the seniority list has been fixed strictly in accordance with Rule 15 Roman 2. That is the finding of learned single judge.
Now, Mr. Siti, just my confusion. Suppose we do away with this seniority list. That is just my views. Just to clear my confusion. We do away with the rules.
no, not to do away with the rules.
No, with
Yeah,
this, I'm sorry, with this
rules.
seniority.
Now,
We-
15.
With this seniority,
Uh-huh.
we actually suppose we actually say that, okay, this tentative seniority is found defective, we do away with this. What will be your position now? If suppose we do away with this tentative, will you say that there will be no seniority in the department?
Question and interfering with the rules. It will be very difficult for this honorable court to issue a direction to violate the law.
To?
So, to violate the law.
No, we
To
cannot,
violate the rules.
we cannot do that, we cannot.
Any direction should be to act in accordance with law.
We can only give a direction to consider amendment of the rules incorporating the post of senior inspector.
Such a direction can also may not be.
No,
given.
to consider, we are not giving any mandate. Because actually, unless that post of senior inspector of supply is incorporated in the service rules, then again, there may be some vacuum there.
Your Lordship, not only the post of inspector of supply, some higher ups, and then some lower grades, many were upgraded.
So maybe unless those things are actually like, those things are settled, we may not be able to give pass any order in this case.
Your Lordship, so this has to be properly disposed of. Otherwise, the department will be, again, they find it difficult.
Yes, Mr. Mua, you are allowing the two senior lawyers to fight. So let us also hear from
Yes,
you.
Your Lordship.
Uh,
Your Lordship, if the reasoning of my senior counsel for the appellants is taken, then it appears that you don't want to be the senior inspector. of
He
supply.
doesn't want to be senior inspector.
Only inspector. This is my understanding, Your Lordship.
There's logic.
Your Lordship, it's very clear, cabinet has taken a decision. And on the basis of the cabinet decision, the appellant as well as the respondents, who responded directly, they were given this senior inspector of supply,
They were all upgraded.
upgraded to senior. Because in view of a cabinet decision, because the cabinet has taken a decision that they should be upgraded. After, and 2002 rule, post of the senior inspector is not yet, it's very clear. It's very clear, it's not yet. So now, it was on 26 April 2017, the upgradation date. Now, when the tentative seniority list, it is not a promotion also, it is a tentative seniority list only. When it was prepared, after the upgradation of both the appellant as well as the respondent on 19/11/2018, by a clerical error, the word seniority was not there.
Mr. Mua, that's why I am saying, you see the date of promotion column. Because actually, if we are to see these dates, then maybe your submission is off track.
The promotion to the present grade is, Your Lordship,
Yes.
not to the post of the senior inspector. not to the post of the senior inspector.
No, date of promotion means the date of promotion to the post of inspector of supply. See, date of promotion, because inspector of supplies, the
Correct.
post was the inspector of supply was upgraded to senior inspector of supply in the year 2018.
2017.
So 2017. So if it is the date of promotion, on the seniority list of inspectors, it would have been after 2017. See, that is why there's confusion there. The date of promotion should have been after 2017.
Your lordship. date
That
of
is
promotion,
the
date of appointment to the present grade.
that's
And
yes.
so far as your lordship, the respondent number 3 is serial A. So he can carry liquid on 19/7/2012 as inspector of supply through FASA.
That is why we are actually putting up the query that this could not have been the tentative seniority list of senior inspector of supply, because actually the date of promotion, if it is suppose 19/7/2012, the day the promotion of the respondent number 3 in the post of inspector of supply. That is why we are saying that there could not have been any tentative error, any inadvertent error.
If your lordship could find out some defects in the arrangement of the things, we are willing and ready to care.
I am not, you just see the date of promotion, the last date is 2016. I'm asking you to assist me on this. Last date is 2016. And they were all upgraded in the year 2017.
Sorry, your lordship.
Yes. Okay, if you want us to hear, we will hear you, but if it is not possible for us to finish, we keep it part heard. Any date thereafter. Since
this week, I may have some problem, so let us make it after 2 weeks.
Lordship, many agencies, promotions are held up because of this building, rebuilding, your lordship. So earlier, it's problem.
any officiating promotion can be given. There is nothing stopping you. But any officiating promotion can be will be subject.
Seniority list is subject challenge.
No, there is no stay. Correct.
Or we can try next week also, if not 2 weeks.
Next week.
Yes.
Okay. Heard Mr. R. Iralu, the Learned Senior Counsel, assisted by Mr. L. Iralu, Learned Counsel for the appellant. Mr. Moimchin, the Learned Senior Government Advocate for the state respondents, and Mr. C.T. Jamil, the Learned Senior Counsel, assisted by Mr. I.M. Chin, Learned Counsel for the respondent number 3 and 4. Listed again on 25. Listed again on 25/9. Or if it will be time consuming, we can list it on 24th. Tuesday,
Okay.
Thursday again on 24/9/2024. Not as spotted. Okay, not as spotted. I think, Mr. Siki, I think you should also give your written argument. I think it will be proper for this court to understand that. Okay. No, this is. Hold on. Shut down the computers. Then 15. Yes. No. 9.